Mark Durso, Senior Assistant State's Attorney, Your Honor.
Edward Davin from Mr. Morales, who's seated to my left, Your Honor.
All right, court will note that Mr. Morales is present. Before I bring the jury in, I just make an inquiry of this date for purposes of the record. Have the decedent's family been notified of the fact that we believe there is a verdict?
Yes, Your Honor,
All right.
and thank you for the time. They were all present here in the courtroom.
All right, very good, thank you. All right, Madam Clerk, please bring in our jury. Counsel, please stipulate to the return and presence of all jurors.
Stipulate to the presence of the jury, Your Honor.
Stipulated, Your Honor.
Thank you. Good afternoon, ladies and gentlemen of the jury. At this point in time, I would ask that you please pay your attention to Madam Clerk. Madam Clerk.
Ladies and gentlemen of the jury, as your name is called, please answer here, rise, and may be seated. Mr. Foreperson, in the case of State of Connecticut v. Jose Morales, docket number AAN CR 20-018-6660T, has the jury unanimously agreed upon a verdict?
It has.
In docket number AAN CR 20-018-6660T, in the first count of the amended information charging the defendant Jose Morales with the crime of murder in violation of section 53A-54A of the Connecticut General Statutes, how do you find the defendant as to the crime of murder?
Guilty.
In docket number AAN CR 20-018-6660T, in the second count of the amended information charging the defendant Jose Morales with the crime of tampering with physical evidence in violation of section 53A-155 of the Connecticut General Statutes, how do you find the defendant as to the crime of tampering with physical evidence? Guilty or not guilty?
Guilty.
Your Honor, may the verdict be accepted and recorded.
Court will order the verdict accepted and recorded. Madam Clerk.
Will all members of the jury please rise with the foreperson and listen to your verdict as it is accepted and recorded? As to the first count of the amended information charging the defendant Jose Morales with the crime of murder in violation of section 53A-54A of the Connecticut General Statutes, you say the defendant is guilty of murder. Do you also say that the defendant is guilty of tampering with evidence?
Yes.
Yeah. Mr. Foreperson, so you say you all, ladies and gentlemen of the jury, you may be seated.
Attorney Gavin, do you request a polling of the jury?
Your Honor, at this juncture, we would ask the court to address the outstanding motion for judgment of acquittal to start off with. And then my second motion would be, Your Honor, pursuant to Connecticut Practice Book Section 42-52, a post-verdict motion for judge.
We'll get to the post-verdict motions in a minute. Are you requesting a polling of the jury?
Oh, yes.
Okay, thank you.
Yeah.
Madam Clerk. Thank you.
Ladies and gentlemen of the jury, I will now call upon each of you to stand individually. Aaron Malone.
Time just to address you briefly and say a few words. The verdict has now been accepted, and it is time to discharge you from your oath. The oath obligated you to keep silent about your role as jurors during this trial. You have now concluded your jury service and are now released from your oath. It is, of course, up to you to decide whether or not you want to talk about your role as jurors in this particular case to anyone. You may, but of course, you're certainly not obligated to do so. I would like to take this time also to recognize you and thank you for your time commitment and your service in this particular case. Serving on a jury in trials, especially like this one, which is fairly lengthy, do take you away from your personal daily affairs, and we do appreciate you being with us, and we appreciate the time and attention that you gave to this case. Now, inevitably, a decision by a jury will gratify one party or some parties and disappoint others. It's a very difficult job that you have. You've been asked to do it, you've done it, and we all appreciate that. Making decisions, as you have just done on this trial, are not easy things to do. So these are, however, decisions that are extremely important to our society, to decedents, the decedents' victims, of course, in general, and also to individual defendants. So we're all very grateful for you in performing this most difficult task. I know that I speak on behalf of all of us for thanking you for your time that you've given us here today. So you are hereby formally discharged. We do have some paperwork for you to receive on behalf of your jury service here. So if you wouldn't mind just waiting in the jury assembly room, the clerk and I will come into the jury assembly room and get that paperwork to you as soon as I make some more comments on the record. So, and that includes our alternate juror, and I do appreciate the alternate juror being here with us. And I know, again, I want to address you. It's often frustrating, but we do appreciate you as well. And you serve a very important function relative to this entirety of trial. So thank you for that service. I would ask you to please also find your way to the jury assembly room with the jury now, and I will be in momentarily. So I'll please direct members of the jury to be excused from the courtroom, Madam Marshal, and bring them to the jury assembly room. All right, so for purposes of the record, a few things. First of all, at the close of evidence, the defense moved for a second time regarding a judgment of acquittal, to which the state objected. The court deferred, reserving decision on the motion and submitting the case to the jury. At this time, I do intend to act on that particular motion as filed. Counsel, do either of you have anything further you would like to say in relation to that particular motion?
No, thank you.
Okay.
Not from the state, Your Honor.
All right, so again, a motion for judgment of acquittal must be granted if the evidence would not reasonably permit a finding of guilt. In ruling on such a motion, the trial court must determine whether a rational trier of fact could find the crimes proven beyond a reasonable doubt. Considering all the evidence and the elements of each of the crimes charged in the state's amended information, the court finds that the evidence presented in this case would reasonably permit the finding of guilt as to both charges, and that a rational trier of fact could find the crimes proven beyond a reasonable doubt. And hereby the motion for judgment of acquittal is denied. Attorney Gavin, you started to talk about some post-trial motions before I excused the jury. I'll take those up now.
Thank you, Your Honor. Your Honor, pursuant to Connecticut Practice Book Section 42-51, 42-52 is the time for filing motion for judgment of acquittal, and also 42-53, the motion for new trial. I'm respectfully asking the court to extend the time period for the filing of those motions for 30 days.
Does the state wish to be heard on that?
I'll defer to the good graces of the court.
All right. Well, given that we have about 11 weeks in between now and sentencing, I'll certainly give you that 30-day request. So I'll extend the motion within which to file those particular post-trial motions,
Your
that
Honor,
extra 30 days.
I would simply ask for an additional 30 days following that for the state's response, if any is called for.
All right. Court will go ahead and give the state that additional 30 days, of course. All right. So at this point in time, we have guilty findings as to both charges, that's murder and tampering with physical evidence. I'll acknowledge those for purposes of the record. Is the state making any motions at this time?
Yes, Your Honor. Now that the presumption of innocence has been erased and the defendant stands guilty of the crimes charged, the state is going to ask for an increase in bond of an additional $2.5 million, please.
Does the defense wish to be heard?
Your Honor, as the court knows, bond is academic. He's been held on a $5 million bond, and I understand that there's a difference now that the verdict has been rendered. He's been unable to post a bond for the last 5 years, so bond is academic. I don't think there's any need to increase the bond $2.5 million above the $5 million currently stated level. Thank you.
Madam Clerk, what is the current bond on the file?
It's $5 million.
All right. Considering there's no longer a presumption of innocence and the defendant has now been convicted of murder as well as tampering with physical evidence, this court is going to increase bond by $2.5 million.
May I request post in court only designation, please?
Certainly, the court will go ahead and make a condition of the posting to be at court only, so that bond must be posted in court before a judge. All right, so with that, if there are no additional motions, the court would like to take this time.
None from the defense, Your Honor.
Not from the state, Your Honor.
All right, so I would take this time to first address counsel and thank you for your courtesies to the court during the course of the trial. I appreciate that, and the courtesies that you've shown to one another as well. And to Mr. Morales, you've now been convicted, but I do want to thank you for your courtesies in your courtroom decorum during the trial. I'd also like to thank the members of the family who have been here diligently every single day to watch this trial unfold, and I want to thank them for their courtroom decorum as well, and that extends to all additional spectators, so thank you for that. Is there anything further?
Just, Your Honor, I want to thank Your Honor and the staff have been nothing but courteous to us during the entire proceedings. We've been here since February, and whether it's the clerk's office or the marshals, Your Honor, the court reporter, everyone has been really wonderful and appreciated that courtesy. Thank you.
All right, so Attorney Gavin, the court will be ordering a pre-sentence investigative report relative to the sentencing proceedings. Do you wish to be notified and/or present?
Yes, please, Your Honor.
Okay, and it appears that our sentencing date is Tuesday, July 8th.
Thank you, Your Honor.
For that PSI to come out. So the court will next see this matter, if not before, on any post-trial motions. The next time this court will see this matter will be for sentencing on July 8th.
Thank you, Your Honor.
All right, thank you. Court stands adjourned.
All rise, court's adjourned.